Go. Hello and welcome back. This is Roger Royce with the 10,000 Startups Podcast, Legal Strategies for Startup Success, where every week we give you new original content with a subject matter expert on a topic of interest in the legal world to startup companies. And today we're doing a special sort of presentation where I am the interviewee and we're going to talk about a certain transaction that I do all the time. It's very common here in Silicon Valley. It's called the flip transaction. And here to discuss it with me is attorney Soyeon Choi, who's an attorney here in Silicon Valley. She does corporate and technology law. And she's graciously agreed to come and speak with me and talk with me about this particular transaction. So thanks for being here, Soyeon.
Hey, thanks for having me. It's such a pleasure. And I'm glad that today you are the subject matter expert.
Yeah, well, I gotta do that once in a while. So here's the scenario. Let me tee this up for you. We have a foreign company, and they've established their business in their home country. Let's make up a country. I don't want to offend anybody.
Country A.
All right, country A. We can be more creative than that, can't we?
Korea?
And okay, they're in Korea.
Okay.
They're in the country of Startup Landia.
All right.
And they've been really successful in Startup Landia. They've got users, they've got traction, they've even got investors. The government has put some money into their company to get them going. And now they've decided is this the call? And let's say that company that has done so well on Startup Landia wants to come to Silicon Valley now. And they want to come here for markets, they want to come here for talent, or they want to come here to raise money. So how do we do that? And that is the flip transaction. We're going to convert that Startup Landia corporation into a Delaware corporation. That's the flip transaction. So there you go, Soyeon. What do we want to know about it?
Okay. All right. So as an initial matter, you have a foreign entity. And so how do you evaluate this? How do you know when that company is ripe to enter the US market or, continue to operate as a foreign entity? And then also, do you have to have a parallel entity here? What's this?
So this transaction structure is pretty straightforward. Step one, we form a Delaware corporation. Step two, with some countries, we can even do a merger into the Delaware corporation, usually not. Instead, what we'll do is what we call, for tax purposes, a type F reorg, but it doesn't have to be. It could be another type of tax-free transaction for US purposes, but the foreign shareholders transfer all their interest in the foreign company to the US company in exchange for interest in the US company. So now, poof, we've got a Delaware corporation owns everything. And as I said, as a US matter, that's pretty simple until you start drilling down into the details. But that's the basic transaction.
Okay, that's a good framework. And so what are some of the security concerns that you would have to shore up before in anticipation, and some issues that we might have to accommodate?
So let's kind of take them one by one. First is the corporate issue. And the corporate issue is relatively straightforward. You either can do a merger or you can't. For example, Singapore, we can't do a merger. They don't have a merger statute. So we'll do that as a stock for stock exchange. So that one's relatively easy. Now, it's easy until it's not. If there's 1,000 shareholders in your foreign company and you got to do a stock for stock deal, well, that's not so easy, is it? So there can be a legitimate corporate issue there. But that's going to become pretty apparent pretty quickly. Second issue, and this is the biggest one, is the tax issue. This is almost always tax-free on the US side. The only time it's not is if we have a US shareholder of the foreign company. And then the answer is maybe. And that's when we got to get the tax department involved, and we have to determine, is there any appreciation in those shares that are coming into the US? Are there any earnings and profits in that corporation that's coming into the US? And, it's an odd counterintuitive thing to think that the US would tax a company for wanting to come into the US, but that's what happens sometimes. Now, we can almost always plan around it, but again, we have to be aware of it.
Mm-hmm.
And then the third and usually the biggest issue is what happens on the foreign side, because usually that's going to be taxable to the foreign shareholders, even though there's no US tax, there's a foreign tax on the foreign shareholder for doing that exchange. So we have to plan into that with foreign counsel, especially foreign tax counsel as well.
Oh yeah, good point. Good point. Speaking of foreign counsel, what are some employment issues?
And on the employment side, that's often a surprising issue for people, because if you're going to establish a company here in the US, especially to go talk to VCs, you're going to have people here. And what people quickly find out is, number one, especially in California, our employment laws are much different than what you're probably used to. For example, if you're in Europe, Europe is harsh, but California is harsh in a whole different way. So that's something to become familiar with. And then secondly, the immigration issues. So you really have to, it's a multidisciplinary transaction. You want to have your immigration lawyers involved, you want to have your employment lawyers involved. And you have to have foreign counsel along every step of the way, because you might not be able to move them quite so easily to the US.
Right, yeah. And a lot of times the value is in the workforce. So you have to make those considerations before you get too deep into it.
Right.
The entire value is, compromised. Yeah, actually kind of parallel but different is, what about the founders? What sort of concerns would they have to consider?
Yeah, the founders, it's kind of the same issue. They oftentimes, they want to come over to the US. That might be one of the motivating factors in forming a company. That is a path. That's possible, but that's an immigration issue, not so much corporate issue. I will say that if they don't want to come to the United States, they don't have to. You can be a board director and live in France. You don't have to be a US citizen, don't have to be a US person. You don't even have to be here. Your bank might want. As I said, your bank might want you to have a person here, but you certainly don't need to be here as a founder in order to form a US company.
Mm-hmm, mm-hmm. Do you have to have any considerations in terms of like equity comp?
Equity comp is a real problem in these deals, not so much on the US side, but from the foreign side, because what the US doesn't tax, other countries will.
Mm-hmm.
For example, we have stock option plans in every company I deal with, almost. And the grant of a stock option is not a taxable event to a service provider under US law. You'll be surprised to learn that is not the case in other countries. So we bring our foreign employees over. We don't bring them over. We migrate the company to the US, and we give our foreign employees US equity. We need to check local law, because in some countries that's going to be a taxable transaction. Now, if it is, I've got a way around that. We'll use a phantom plan. We'll use a bonus plan. Maybe we'll use a special type of incentive that's authorized in that country. We'll figure it out, but it's the kind of thing we need to be forewarned about.
Okay, yeah, that's good to know about. Sort of like on a similar line of questioning, is there a lot of friction or education that needs to be done in terms of US side management, or updates on how to then transfer and run their company here, a foreign entity here?
Yeah, that's a little beyond my pay grade. What I will say though, and this is kind of a sleeper issue, is in other countries, governments tend to be far more involved in their startup community than they are here. They will make investments. For example, I've had several German companies come over that had government money. I've had Singapore companies that had Singapore investors. And that's how they get off the ground, and that's how they get started. And there's nothing wrong with that, except that they may be prohibited from moving to another country. And even if it's not a government investor, they might have to get the consent of their foreign investors to move to the US, and the foreign investor might not want to. Or It might be that they lose incentives. Australian companies have this issue. They might lose local incentives by migrating outside of Australia. So all of these are really foreign issues, but they should be on the checklist for people to think about.
Mm-hmm. In terms of your practice and who conducts that diligence, or do you want that diligence done before you talk to the client, or?
No, that's going to be a joint project, between us and foreign counsel. I mean, they'll tell me that they want to move the company here. I'll tell them what we need to do as a US matter, and we'll go through my checklist and make sure we've covered everything as the foreign matter. The other thing that comes up as a US matter is the securities laws. Because coming into the US doing this transaction, I mean, the US company is issuing a security, right? So we want to make sure that we comply with the securities laws. And this is all often a surprise to non-US persons that we have a dual system here in the US. It's not just federal securities laws, it's federal plus up to 50 states. So we got blue sky laws to comply with as well. So that's something else we want to take a look at. And I guess while I'm at it, I want to think about the IP issues also. Where do we want that intellectual property to be owned at this point? Because if we're going to move it into the US, and sometimes the investors want that, now is a great time to do it, right? Do it now rather than later, especially if we can do it on a tax-free basis now.
Right, exactly.
On the other hand, you might not want to, right? I've seen companies inadvertently turn their non-taxable intellectual property into taxable intellectual property by doing one of these transactions without really thinking it through. Another reason you got to walk down the hall and get your tax people involved.
Yeah, it seems like IP counsel could help.
Definitely
advise
IP
them.
counsel, definitely. And foreign IP counsel as well. So I hate to make it sound so complicated, but there are a lot of moving parts to these transactions. But just so you know, even though I've gone through a zillion issues here, usually they're much smoother than that. Usually, we do this early enough where we don't have 1,000 shareholders. We don't have problematic investors. We don't have several classes of stock, which we try to mimic in the US. So, we don't have all these employment and equity comp issues, and we don't have all these tax issues. But I will say that I have run into all of those issues, throughout all of the deals that I've done in various degrees.
Right, yeah. I mean, it's basically usually very contextually driven, right? Because it's the needs of a particular client at that time. And so you have to figure it out as you go.
Yeah. And on the finally on the corporate side, I didn't mention this earlier, but corporate financing documents, if you do have investors in a company, they can look much different in other countries than they look here.
Mm-hmm.
And what we're trying to do is mimic the deal terms and do as little violence to the business deal as possible while trying to stay close to market in the US, because we're doing this so we can go out and find US investors. And sometimes that works and sometimes it's a lot harder. For example, investor terms in Asia can be much more investor friendly than we see here in the US. That's even true in Europe. UK shareholders agreements have a lot of what we have in the US, but also a lot of other stuff. UK shareholder agreements also have little slight differences, not just UK, but throughout the rest of the world, slight differences in managerial rights that shareholders and owners and investors have than the US documents have. So we never get a perfect mirror, but we want to get as close as possible.
Yeah, that's true. And actually, I do have a practical question about the preservation of the now converted or flipped entity. So you keep it a library of the previous documents, and then also are there translation issues in terms of language?
Yeah, good point. Sometimes we will have language issues. I only do my work in English.
Uh-huh.
And I'm sure you've probably seen this too, Soyan, where you've got the documents, and on one side is the English, on the other side is the translation. Just make sure we have a clause somewhere in there that says the English controls,
Uh-huh.
so I know what we're getting into. But we can deal with that.
Right. Yeah. It's interesting. It's a global economy now.
All right.
Well, I think that's it for time.
I think so. Thank you for doing this with me. This is a very hot, popular, common topic, so I've been wanting to talk about this for a long time. I'm Roger Royce. This is 10,000 Startups, Legal Strategies for Startup Success. I've been talking with Soyan Choi, a lawyer in Palo Alto who does corporate technology. Thanks very much, and we'll see you all next time.
Thank you.